Good afternoon, Dr. Von Gernert.
Good afternoon, Mr. Schachter.
We were finishing off the petition of March 1874 from Fort William, and I just wanted to observe it. Page 158 of the compendium, the last page of the letter. Again, this is Shoney translating this petition, right?
Yes,
But he goes a little bit further than from his February 12th version. In this one, he actually goes to the trouble of certifying that the petition as above embodies the words, thoughts, and feelings of the Indians. And they have put their mark or handwriting, but after they have thoroughly understood and acknowledged their own sentiments. See that?
yes,
That's a little bit different than the February 12th petition in 1873, yes?
yes, to the extent that Shoney doesn't provide any certification of this sort. Although I have no idea why he would deviate from his usual practice unless he had a concern that perhaps, you know, his translations were not taken seriously or something.
Okay, so there's no explanation, but we do see that the Anishinaabe appear to sign with an X, and we have a certification from Shoney.
Yes, he also uses another difference is he uses the ordinary salutation at the end, the most humble and obedient servants, which is the way that non-Indigenous correspondents would end their letters. So he has obviously formalized this more so than he had the earlier ones.
Okay, but we don't know why.
No.
All right. If you go over to page 159, you'll see Dawson's letter of March 20th, 1874, in which Dawson encloses that March petition to the Governor General. See it? You agree that that's what the letter is?
Yes, I deal with this on page 230 of my expert opinion.
And you agree with me, sir, that in the second paragraph, he talks about this petition refers to a claim which the Indians have from time to time advanced for payments which they claim to be due to them under the Robinson Treaty.
Yes.
No mention there of any limit or cap.
No.
And the letter then goes on to ask for an advance at the bottom.
Yes.
There was no advance given. Is that correct?
That's correct.
Then we have at page 160, Laird's memo of 1874, which is the next thing that happened after the petition and the cover letter. They made their way to Laird, correct?
Yes.
But by the time it makes their way to Laird in June 17, 1874, it looks like Mr. Boron's gotten involved, right?
That's correct. He's now become, well, he's member of parliament for Algoma, and he gets involved submitting arguments on behalf of the Anishinaabe.
All right. Now, you, I think, in your report identify that there must be a letter from Boron that went to Laird because Laird mentions it in his June 17th, 1874 memo, but Boron's letter has not been found, correct?
Yes, at footnote 481 on page 233 of my report, I say that the correspondence is not in the record, but is alluded to in Boron's letter to Meredith of August 6, 1874.
Thank you. And what Laird identifies Mr. Boron as saying is, and I'm going to read it from Laird's memo, Mr. Boron, Member of Parliament for Algoma, has submitted on behalf of certain Indian bands of Lake Superior, parties to the so-called Robinson Treaty, their claim to have the annuity granted them under that treaty increased in accordance with its provisions. See that?
Yes,
Again, no reference to any limit on what's being claimed, right?
yes,
And then Laird goes on to quote the full portion of the augmentation clause, correct?
yes,
And then Laird's memo continues. The undersigned finds that the number of Indians affected by the treaty is stated at 1240, and that according to the last census is 2,759, and that the amount of annuity paid to each at present falls short of $1 per head. That's an accurate statement of the facts at the time, right?
no, it is not.
All right, so he was a little bit wrong then, Laird, about the dollar amounts.
As I said on page 234 of my report, most striking are Laird's figures for the RST population, 2,759, and per capita annuity, less than $1, which were grossly inaccurate. Sprague, who had actually examined the pay lists, had concluded that the RST payments had lately been $1.49½ and the RST census return for 1871 had shown a population of 1,453. And I go on to give the other numbers as well.
So for some reason, Laird doesn't seem to be too concerned with the numbers then, is of the per capita numbers. Is that what I'm to take of that?
Yeah, this is, keep in mind, this is now a change in government. This, you know, he's new to this file. He doesn't, he simply does not have the numbers that Sprague, who had died in the interim, had before him. So these numbers are just incorrect.
Well, perhaps the numbers aren't important to him. Let's see what he actually says in the next sentence. Under these circumstances, it is submitted that they are entitled to the benefit of any increase in the annual annuity of that which can be granted under the terms of the treaty. He doesn't ask for $4.
That's correct.
Sprague asked for $4. He doesn't. There's a difference, right?
Well, again, there's no, when you continue this forward, there's no question at all that Laird has in mind a $4 maximum annuity.
Sorry, where in this memo does Laird talk about a $4 annuity?
It's not in this memo, but when you continue with his calculations as I explain in chapter 5 of my report.
So the judge can read your report, but this memo itself doesn't provide any reference to $4. You'll agree with that, eh?
Yes, at this point in time on June 17th, or I should say yes, on June 17th, 1874, he makes no reference to the $4 maximum.
Okay, in the last paragraph of his memo, in the fourth line, he says, "It is submitted that the attention of the local government," that's Ontario, right,
Correct.
"should be called to the terms of the treaty," that's the Robinson Superior Treaty, correct?
Yes,
"And that they should be invited to enable the Dominion government to make such increase in the annuity thereby secured to the Indians as they may be thought entitled to under its provisions."
yes.
Now, I'm curious about the manner in which Laird identifies the words "enable the Dominion government to make such increase." Do you understand what the word paymaster means?
Well, I've heard the term, but I wouldn't hazard a
Okay.
guess if you're giving it a legal context.
All right, well, it sounds to me like what Laird is suggesting is that it's the Dominion government that's going to actually turn over the money, not Ontario. Is that how you read it, or do you read it differently?
So the Dominion government is at the time paying the pre-augmented annuity. And so he's suggesting that Ontario should be invited to enable the Dominion government to increase the annuity, the current annuity that the Dominion is paying.
Right.
And that's why he's suggesting that the memorandum be passed to Ontario through the Secretary of State.
But can you provide the court with any insight into what he means by enable the Dominion government to make such increase? And I'm trying to focus in on, is Laird on behalf of the Dominion
Yes,
thinking the Dominion is going to actually do the paying of the money regardless of whether Ontario is ultimately responsible for it, or do we know?
yes. Laird was under the understanding that the Dominion would pay the increase until the matter would be adjudicated at some point in the courts and a decision was made otherwise.
Okay. And the reference in Laird's memo to "as they may be thought entitled to," who's the they?
I understood that to be Ontario. Ontario was supposed to look at this and based on the proceeds, determine what the Indians were entitled to under the provisions of the treaty. I mean, this is similar language to what you see in some of the other orders in council, for example, where Canada is sending Ontario these orders in council and saying, look, here's the issue, here are the treaties, you know, kindly proceed based on your understanding of the treaty.
So your understanding of the use of the word "they" there is not to the Anishinaabe, but to Ontario?
That's the impression I had from, you know, given that this is similar to the wording that you find in some of these orders in council, which are more specific.
So is Laird's understanding then that Ontario gets to decide what the Indians are entitled to under its provisions? Is that what Canada's trying to communicate?
Well, Laird wants the data from Ontario. And Laird already is thinking of a way in which that data can be converted into an annuity augmentation. But it's kind of leaving the decision on how much that quantum is to Ontario.
That's exactly the point. That's what I'm trying to understand here. It's the Canadian government, the Dominion, is, although they're going to be doing the paying, they're leaving it to Ontario to decide?
Well, they're leaving it Ontario to decide, for instance, that, you know, that keeping in mind that Dominion of Canada has no access to the calculations and doesn't know what would be considered, for example, a cost that needs to be put into the equation for net proceeds. They're leaving it to Ontario to decide those matters, but they want action from Ontario because Ontario has the data on the proceeds. And so in the follow-up to this 1873 or 1874 correspondence, later on, you'll see that Laird is in fact, again, asking for the proceeds data. He's leaving that to Ontario.
No, my point that I'm trying to understand from this document and from what you know about history is whether the Canadian government has anything to say about what are appropriate expenses or revenues. I mean, because we know the arbitrations, there was some discussion about that.
Yes.
But was there a feeling amongst Canadian officials, in your view, that it wasn't Canada's place to intervene? Is that a fair assessment of the state of play of the mind of Canadian officials?
No, the state of play is that Canada understands that there's a solemn duty to augment these annuities. It also understands that it does not have control of the proceeds from the lands anymore.
Right.
Or the Dominion never did. However, Ontario, according to the Dominion, has the responsibility to provide the information necessary to identify, for example, the years in which augmentations were due. You know, that's not something that the Dominion had any control over. What the Dominion did have control over is once it received the information, a calculation could then be made by the Dominion, which would result in the augmentation.
So the Dominion wasn't out of the picture. When it got the information, it could dispute
Yes.
the expenses, correct?
As it did later.
It could dispute the revenues amounts. My point
Well,
is that the
well,
government,
it couldn't really dispute the revenue amounts because the revenues are as they are. What it did dispute was who ultimately was liable for paying the difference between the pre-augmented annuities and the fully augmented annuities.
you haven't examined the complete record of the arbitrations, have you?
I've read when you say examined, as I indicated earlier in my testimony, I was under the assumption, rightly or wrongly, that there were other experts dealing more meticulously with the arbitration matters. And so I did not examine them with the same scrutiny as I did much of the rest of the material, but I
Okay.
did read them.
Okay, thank you. You would agree with me that Canada is not out of the picture in implementing the Robinson Superior Treaty in 1874?
Yes.
You'd agree with that?
Yes.
All right. Over on page 161, we actually have the OIC that eventually goes to Mowat
Yes.
or to Ontario. And in the middle of the page, we see that the OIC says, under these circumstances, and it's really just repeating Laird's memo. It's on the computer screen to your left if you want to look at it. Under these circumstances, he submits that they, and that's referring to the Anishinaabe, are entitled to the benefits of any increase in the amounts of the annuity which can be granted under the terms of the treaty.
Yes.
And then on page 162, Meredith encloses the treaty, the memorandum, that's Laird's memorandum,
Correct.
and the OIC that we've just read from.
Correct.
And that's what goes to Ontario.
Yes.
And in the 1874 OIC, there's no reference to any claim to annuity augmentation to the extent of $4. It's just a claim to any increase in the amount of the annuity which can be granted under the terms of the treaty. There's a difference.
Yes.
Now, Mowat eventually responds to the OIC of 1873, in which only $4 is asked for, correct? He never responds to the 1874 OIC.
Yes. The 1874 OIC is puzzling to begin with in light of the July 9th, 1873 order in council.
Well, puzzling because they didn't just say, please respond to the 1873 request. That would have been what would normally happen, right?
There was already a July 9th, 1873 order in council, which had brought this whole matter that Canada was raising to the attention of Ontario through formal channels. And Mowat responded to that. The 1874 order in council, I say is puzzling to begin with, because it's almost as if it's almost as if Canada forgot they had already sent an order in council the previous year.
But we've just talked about them asking for two different things. One asks for an annuity augmented to the extent of $4. And the 1874 one doesn't ask for that. It asks for any annuity, and I'm paraphrasing, but I think you'll agree with me, any annuity to which they're entitled, or any augmentation to which they're entitled. Those are different requests.
Ontario did not understand them to be different requests. They responded to the 1873 order in council, and there was no response in the record to the 1874 order in council.
So Mowat responds, and I don't think we need to go over the documents in the record. Mowat responds that they should be paid the $4 per capita amount, right?
Yes,
And he identifies that that's what they asked for, correct?
yes,
But he didn't know that it wasn't the Anishinaabe who were, sorry, he's only got Sprague's fact sheet that identifies that that's what they're asking for, but he doesn't know what they're asking.
Ontario was always under the assumption that the claim was to a $4 maximum.
They would not have been, no, sir. Would you agree with me that when they got the 1874 OIC and the treaty and the memorandum, that they would not believe that the request was limited to $4, to the extent of $4? Would you agree with that?
No, all I can say is that what they understood was that the claim was to $4. And that is amply reflected in the way in which they treated this entire response.
Perhaps we can go to page 175, which is the last document in the series. And this is July 30th, 1875. Meredith writes to Boron. Remember, the 1874 request for whatever they're entitled to hasn't been responded to. Remember that Boron was the one of the people that instituted that request for whatever they were entitled to. And Meredith finishes his letter by saying, the subject of the claims of the Indians to increase of annuity at an increased rate will be brought up for early consideration. That's, as far as I can tell, that's as far as it goes with Mr. Meredith in 1875. Now, we had Van Kunet in, I guess, in the 1890s, suggest that it was part of the arbitration and then it would not be lost sight of by Newcom. But there doesn't seem to be any follow-up after this email, after this correspondence from Meredith to Boron. Do you agree that I haven't found any follow-up?
Well, this is now July 30th, 1875.
Yes. They've been authorized the $4 payment.
Yes, so he is, that's right. He is writing back to Boron because Boron has been pressing him from time to time to get on with this. And Meredith finally writes back on July 30th that it's been authorized.
Yes.
That the payment will be increased to $4 per head for the current year, because keep in mind his calculations were only for the immediate year of 1875.
Maybe $5 for the next year then? If that's what he meant by only $4 for the current year, $5 for the next year, I didn't, what are we to take from that?
Oh, the only thing you can take from that is that Laird understood that this had to be voted on every year. And, you know, he couldn't make any promises as to what's going to happen the next year.
Do you have any other comment on Mr. Laird's memo?
Well, I did want to refer to my report where if you give me a moment. Because I recall talking about this. Canada's a comment that I made in my report was that
What page are you at? Sir?
this is at page 429 of my report. I was referring to Canada's August 9th fact sheet sent to Ontario, which made it clear that the Indians of Lakes Huron and Superior were claiming the fulfillment of the augmentation clause to the extent of $4 annuity per capita.
Yes.
And that's included in my section summarizing the understanding of the Crown of the augmentation clause.
Yes.
Right? It's included in that section of my summary.
Okay.
Because that's how I understood Ontario. That's how Canada communicated the claim to Ontario, was through that fact sheet.
Okay, thank you. I agree with you that's the August 9th fact sheet that says $4 to the extent of $4. But I had asked you about Laird,
Yes.
and you have nothing further to add about that.
Well, Laird, of course, did all of those calculations based on the assumption that it was in fact $4.
Okay. I guess the last thing I would do before I close my cross-examination is ask that this compendium, which the witness has identified all documents that were not in the record as being known to him. With my friend's consent, I would ask it be marked as a numbered exhibit.
54. Oh, that's 54.
Yeah, I take it my friends don't object. Okay, no from Ontario. And Ontario, Canada is fine as well. Dr. Von Gerner, it's been a couple of long days. I want to thank you for your patience with me. And I think someone else might have a couple more questions. Judge might have some more questions, but thank you.
Thank you, Mr. Schachter. I appreciate it.
So yes, what was exhibit Q will now be known as exhibit 4. And given for cross-examination.
taking a minute to get set up.
Once you do get set up, I should have.
Yes, certainly. So I had passed up to Madam Registrar a copy of a cross-examination compendium. I've also provided hard copies to my friends. So just ask at this point that it be marked as the next lettered exhibit, which I believe is Exhibit R.
Correct.
I may also be making reference through my cross-examination to the reports of Dr. Von Gernert, Dr. Von Gernert's slides, which are exhibits 52 and 53, as well as potentially my friend's cross-examination compendium, which we just marked as exhibit 54.
Very good. So 53, please.
53 is the slide deck for the perspectives report, as I have it.
Possible, I don't have it. And I'll just ask you before you start, sir. Obviously, address.
Certainly. I will certainly try my best, but if I happen to forget, please
I'll
remind
ask
me.
someone else.
Good,
I've got stuff.
okay, excellent. Good afternoon, Dr. Von Gernert.
Good afternoon.
And I had introduced myself to you briefly yesterday, I believe. My name is Spencer Bass. I'm counsel for what we've been calling in this trial the group of seven First Nations in the Robinson Superior area. And I have some questions for you this afternoon. And just to start off with, you're quite clear in your reports, I believe, that you're not offering any legal opinions, correct?
That's correct.
And certainly throughout your reports, you may make reference either to the law or legal decisions or legal conclusions of various actors, correct?
It's a necessary consequence of overlap in our professions, but I do not purport at any time to offer a legal opinion.
Right. And to the extent that you make any of these references, they shouldn't be construed as legal opinions, correct?
Yes,
And you, of course, accept that this court should come to its own conclusions on all of the legal matters in dispute.
of course.
So starting with your just demand report, I'm going to call it that as a short form. That's the lengthier of the two reports. I think you'd agree with me that it's extensively footnoted.
Yeah, it has over 800 footnotes.
That was actually my next question. I believe at my count, it was 818. Does that sound correct?
That's probably correct.
I'll mention I just went by the number on the last footnote. I did not count them individually. But I think you'd agree with me that that's a lot of footnotes.
For my reports of this length, it's not a lot. It's about average.
About average, about standard for your reports?
Yes.
And in large part, these footnotes reference original primary sources.
Yes.
Those would include letters, correspondence, petitions, memos, reports written by actors in the 19th century.
Yes.
And so I take it that where you identified a document in the historical record that supported a fact that you were mentioning in your report, you cited to that record in the footnote?
I tried to, yes.
And I want to refer to the text of the Robinson Superior Treaty for a moment. You'll agree with me that the text of the treaty contains a payment date of August 1st?
I think it was before, the wording was prior to August 1st.
Right, and in fact, the wording is that the annuity, quote, or is, quote, to be paid and delivered to the said chiefs and their tribes at a convenient season of each summer, not later than the first day of August.
Correct.
Does that sound familiar? So as you mentioned, it's that the payments are to be made by the latest August 1st.
Yes,
And in fact, this is a difference that we see between the Robinson Superior Treaty and the Robinson Huron Treaty, correct?
yes, there is, as far as I recollect, there was no specification of a date. It was just at a convenient season. I'm not sure what the exact words were, but it was something to that effect.
And you're referring to the Robinson Huron Treaty?
Yes.
Yeah. So the Robinson Huron Treaty just requires the payment at a convenient season of each year,
Yes,
but it doesn't refer to August 1st.
yes.
And so concerning the August 1st date, I want to go to page 91 of your just demands report. And I'm looking at the start of the, I guess, the first full paragraph that starts on that page, or second paragraph on that page, where you note the Fort William cash distribution commenced on August 5, technically 4 days late, although the date specified in the treaty was always aspirational. Conditions in remote areas rarely allowed for punctual attendance by all parties. Do you see that?
Yes,
And so you note in that passage that the August 1st date in the RST was always aspirational.
yes,
And is it your opinion that both parties to the treaty, that is both the Crown and the Anishinaabe, in signing the RST, viewed the August 1st payment date as aspirational?
I don't think that at the time of the signing of the treaty, it was understood as aspirational. It was probably understood as a hard date. But once the practical issue arose, that is, Anishinaabe people simply were not available to receive payment by August 1st. It became aspirational after that. And in fact, from August 5th of 1851, as early as that, the very first payment from then on, I don't recall it ever having been paid on August 1st. It was paid, there was no single date. At the end of the day, there was never a single date. It was always done, whoever was present at either Fort William or Michipicoten or Nipigon House would be paid at the time they were present, irrespective of the date. So in that sense, the August 1st deadline became meaningless.
Okay, so I want to dig into that a little
Sorry,
bit.
Did you say there was a moment when it became meaningless? You say after the first one?
Yes. Because right from the beginning, right
It's
from,
not because I just want to know what you said.
yes.
So if I understand your answer correctly, then, though, although you write in your report that the date specified in the treaty was always aspirational, what you mean is that when the treaty was signed in 1850, it wasn't aspirational and it was meant to be a hard date, I believe is what you said,
Yes,
but it became aspirational afterwards.
yes.
And you'd agree with me that you don't cite any source in your report for this statement?
Nobody actually said that it was always aspirational. It is my conclusion based on a scrutiny of the actual payments and the dates these payments were made.
Okay. So you said it's a conclusion that you made.
Yes,
So would it be fair to classify it as an assumption that you made?
well, from the perspective of the Hudson's Bay Company, who was mandated to provide these, they tried as much as possible to, or they aspired to meet an annual summer date. But in practice, it ended up being impossible.
Right. Thank you. That wasn't exactly my question. My question was about the statement in your report that the date specified in the treaty was always aspirational. That was an assumption that you made.
No, it's actually a conclusion that I reach based on the actual practices of the Hudson's Bay Company actors.
That's fine. And so at page 91 of your report, you don't identify it specifically as your conclusion, do you?
No,
You'd agree with me, it's stated as a fact in your report?
it's stated as well, I think anyone reading it should, unless I've written it inelegantly, should see it as a conclusion based on the fact that conditions in remote areas rarely allowed for a punctual attendance by all the parties. And I demonstrated that through actual facts on the ground. You know, when the annuities payments were being made at Fort William, for example, there were only a few families from Lake Nipigon who showed up. And so they obviously could not be paid if they didn't show up. And so for them, the date had to be shifted to a later time when they came out of the bush and headed for supplies at Nipigon Post. So as a matter of practice, you couldn't have a single date. I mean, whoever came up with the August 1st date may not have appreciated the full complexities of the seasonal rounds of the Anishinaabe subsistence quest, which was not based on any calendrical punctuality.
And so the August 1st date, it was in the treaty though. It was stated in the text of the treaty.
It was stated in the text of the treaty, that's right. And as I said earlier in my testimony, that was one of the breaches, if you will, of the treaty. I mean, I've already stated that in the record, that it was that technically it was not in accord with what the treaty actually said.
Right, and you also say in your report that the date was always aspirational, and that's the
Yes,
the comment that I'm attempting to understand better here. So my question before was, I think clear, in your report at page 91, you don't identify this statement about the date being always aspirational as either your conclusion or your opinion. Would you say that that's fair?
well, I'm giving it as an opinion based on the facts that I had before me. I mean, the fact of the matter is that the HBC agents who acted on behalf of the Crown to distribute these annuities tried as much as possible to assemble people on a certain date, but that just didn't happen because people were out hunting and fishing and
I don't
engaged.
think we need an explanation for why you made the conclusion. I don't think that's what Mr. Bass is asking. We could focus on the question.
Thank you, Your Honor. I was hesitant to interrupt the witness there, but my question just was that in this statement in your report, you do not identify it as an opinion, or you do not qualify this statement as your opinion.
I don't, my report does not end every opinion with a statement that this is an opinion, right? I mean, the nature of providing historical opinion is such that it's part and parcel of the discourse of presenting facts. There's always a combination of facts and opinion. And there's no need to, for every single sentence, identify something as an opinion. But I'm perfectly happy to agree with you that I do not identify it as an opinion.
So your evidence then is that there are, throughout your report, throughout your 450 page report, there are various of your opinions that you do not explicitly identify as your opinions.
Well, I would hope that in the vast majority of cases, my opinions are self-evident and are articulated in a fashion that is clear.
Okay, let's move on then. So the next area I wanted to discuss concerns the government's mining policies. And you discussed this a bit in your report, correct?
I discussed it at some length, yes.
Yeah. And you would accept that throughout the second half of the 19th century, the government, I guess, whether it was the government of the United Province of Canada, which later then became the Ontario government, enacted different policies towards mining?
Yes.
And perhaps my language was a bit inelegant there. I didn't mean to suggest that the United Province of Canada became the province of Ontario wholesale, but at least as it came to mining regulations, that's who took over.
Yeah, I assume, I was going to interject, but I assumed that's what you meant.
And so the government enacted different revenue structures as it came to mining, correct?
Yes.
And so some of the examples that you discuss in your report is that initially there was no royalty being charged on mining, but the mining companies would pay an initial licensing fee of £150, which would count towards the first down payment for the purchase of the plot of land. Do I have that correct?
That's the mining regulations of 1846.
Okay. And then even within that scheme, the Crown made adjustments over the years. And for example, they changed the price per acre for mining lands. Is that right?
Correct.
And they also changed the minimum amount of land that a company needed to purchase.
That's correct, significantly.
And then in later years, the Crown actually did end up imposing a royalty fee. Is that correct?
There was a period later where a royalty fee was part of the mining regulatory regime, although it was I think that it was again changed.
Right. You've anticipated my next question. The royalty was subsequently repealed after complaints from industry, right?
Yes.
And so my point here mainly is that there were different options, both available to the government and pursued by the government, in how to regulate the mining industry in the province. Would you agree with that?
Yes.
And these different policies had different impacts on government revenue from the mining sector.
Yes.
And as an example, some of these arrangements would decrease the revenue coming into the government from mining.
Absolutely.
And throughout your first report and in your testimony last week as well, seems like a long time ago at this point, you made a distinction between annuity funds and land funds. Do you recall that?
Yes.
And you made the point that annuity funds were not paid directly from the proceeds of land.
Yes.
And you went on to explain how the annuities for the Robinson Superior Treaty, at least in the early years pre-Confederation, were funded out of the Consolidated Revenue Fund of the United Province of Canada through annual legislative grants.
Yes.
And so I do want to focus on this pre-Confederation period for a minute. And so we're talking about the Consolidated Revenue Fund of the, I've been calling it the United Province of Canada. Is that the language that you use, or do you prefer a different language for the colony of Canada West and Canada East?
It's fine to call it the United Province of Canada,
Okay.
although they often just refer to the jurisdiction as a province of Canada.
Right.
But it makes more sense now that we know that there was a Dominion of Canada as well later.
So certainly I want to avoid confusion with some of the other government entities that we've been discussing. So let's stick with the United Province of Canada and their Consolidated Revenue Fund. And to the extent that there were sales of land, Crown land, being made to settlers or farmers, these proceeds would have been received by the United Province of Canada into its Consolidated Revenue Fund. Is that correct?
Yeah, at the very beginning, there was a territorial fund, but later on it was a Consolidated Revenue Fund, which consisted primarily of, the vast majority of it consisted of excise duties and customs. But some of it came from land sales as well.
Okay. Well, that was my question.
Let me
That's
just make sure I have
My
the
apologies.
question and it's probably both of you. But your question was, to the extent that there were sales of land to settlers or farmers, the funds were, and frame it in the passive tense, the funds were received by the UPC in the CRF? Or is it that the UPC took their proceeds and put it in the CRF? Is that the same thing?
I don't necessarily see a difference between the two of them. I think the point that I was just asking Dr. Von Gernert was that these funds ended up in the
Okay,
United Province of Canada's Consolidated Revenue Fund.
thank you.
And we just discussed how the original mining regulations right around and immediately after 1850. We're not a royalty scheme, but a land sale scheme, if you will. And so the money from these land sales for mining, those would have also ended up in the Consolidated Revenue Fund?
The money from under the mining licensing system.
Yes.
Yeah, I'm not sure. I can't be certain about that, but I can only assume because they were understood to be land funds that they ended up ultimately in the consolidated revenue.
That's fair. Thank you, Doctor. And so when the government eventually did institute a royalty fee, which we discussed briefly, this royalty fee would have also ended up in the Consolidated Revenue Fund, or do you know?
I don't know that for certain.
And you discussed briefly in your testimony last week as well about the province beginning to collect funds for timber rights and timber licensing. Do you know if these would have ended up into the Consolidated Revenue Fund as well?
I'd have to go back into the, I remember seeing a description of the components of the Consolidated Revenue Fund, which is where I got the percentages of how much came from excise duties as opposed to territorial revenue. I don't recall seeing timber being specified, so I can't give you a certain answer.
And you say you don't recall timber being specified, but you can't say whether that's because the timber revenues ended up somewhere else or that for the particular years that you looked at, there weren't timber revenues.
Yeah, I can't tell you one way or the other.
Okay. So to try and I'm trying to understand how this scheme work, the financial arrangements work. So we have money from, certainly at the very least, land sales, possibly mining royalties, possibly timber rights. We're not sure on those, but they come into the government. They go into the Consolidated Revenue Fund, this big pot of money, alongside money from other sources, excise duties and other funds, and they all get mixed together, and then the annuities get paid out from this pot. Is that your understanding?
Yeah, on page 59 of my report is where I talk about this. The fund from which these annuities were drawn held, this is now in 1852, for example. The fund from which these annuities were drawn held a total of 842,000 pounds derived overwhelmingly from customs and internal duties. A meager 19,961 pounds came from the territorial revenues of the whole province. So the territorial revenues I'm uncertain what they included, but they presumably included sales of lands to settlers in Southern Ontario, or what is now Southern Ontario. I don't know what else that territorial revenue included. I just noted that I have it in quotation marks because that's the term they used.
Right. Well, so I'm just trying to understand, because we know that we're at least talking about pre-Confederation at this point. We know that, as you say, the Robinson Superior annuities are being paid out of the Consolidated Revenue Fund. And so I'm trying to understand where the money in that Consolidated Revenue Fund is coming from. And I think we have your evidence that certainly land sales went into that fund, potentially mining royalties, potentially timber rights and timber licensing fees, as well as revenues from other sources as you identify. Is that fair?
Yes, and because, and by the nature of the consolidation, there was no traceable link between what was going out to fund annuities and what was coming in from potentially from those sources.
Right. No traceable link, you say, but at least potentially an indirect link.
Yes.
So I want to touch on the issue of arrears. And I actually wanted to go to slide 139 in your just demand slides. Let's start there. 139 of the just demand slides, which are exhibit 52. And at the third bullet point on this slide, you identify the years for which the governments, being Canada, Ontario, and Quebec, agreed that augmentations were payable. Do you see that?
Yes.
And so for the Robinson Superior Treaty, they agreed that augmentations were payable in 1853, 1854, 1856, and 1872 to 1874, right?
Yes.
And then for the Robinson Huron Treaty, they agreed that augmentations were payable in 1873, 1874, and then 1881 to 1892.
Yes.
And I would assume that these years weren't just selected at random, correct?
No, they were based on estimates that were produced during the 1890s. As far as I know, they were not based on Johnson's reconstruction in 1879 or on Russell's data from the 1850s. So they were based on a reconstruction that Emilius Irving had commissioned that the province undertake. And so I think Ontario presented the figures, and then there was an agreement reached by the three parties to accept those.
And you already mentioned that the numbers weren't based on Johnson's numbers, so we could probably do this fairly quickly. If you go to slide 113 of your just demand slide deck, this is where you provide the chart of the revenues and expenditures for the Robinson Superior Treaty area based on Johnson's numbers in 1879, right?
I'm sorry, which slide?
Slide 113.
Yes, these are based on Johnson's statements in 1879.
And if we compare the chart that you put together at slide 113, if we compare that with the years for which the government's agreed that augmentations were payable, we'll note that they don't match up, right?
Yes,
You're saying compare with 139?
Compare with the years that were identified on slide 139. And so, for example, the Crown, the governments don't agree to pay arrears for the years 1864 to 1866, but based on your reconstruction of Johnson's numbers, or your presentation of Johnson's numbers, those were net gain years for RST, correct?
yes, it looks that way.
And I take it, we don't need to go through the same exercise, but if we went to your table on slide 114, which are the Robinson Huron numbers, we'll similarly see that the years don't match up 100%, correct?
Yes, which suggests to me that they're well, one has to one has to keep in mind that the latter numbers, the ones in the 1890s, were the consequence of the arbitration process, which among other things identified what were legitimate expenses and not, right, which may have been different from what Johnson understood in 1879.
And so if we compare Johnson's numbers with the numbers that were prepared by Irving, they won't match up for every single year based on what you just told us, correct?
Yes, I mean, that's obvious.
And so maybe I'll just note for the record that the Irving numbers that we're discussing are Exhibit 1-2159 in the Joint Book of Documents. I don't think it's necessary to go to that document specifically unless you need to go to compare the Johnson numbers with the Irving numbers.
No,
Dr. Von Gernert?
I agree that there are discrepancies between them.
Okay. And I believe you told us this last week when you were discussing Johnson's numbers, but you don't vouch for the accuracy of Johnson's numbers. You just presented them exactly as he did in your slides, correct?
That is what I did, yes.
And similarly, you don't vouch for the accuracy of Mr. Irving's numbers in the 1890s.
That's correct.
Just looking at the time, Your Honor, perhaps I can cover one more brief area with one document before the afternoon break, unless you'd like to take it now. Okay. So now, Dr. Von Gernert, I want to discuss with you a particular letter that you actually discussed in your stage 1 evidence, but didn't mention in your testimony before the court on this stage. And so it's actually contained, do you have? Actually, did I ever provide you with a copy of my compendium?
No.
No, so let me do that right now.
Thank you.
So this is the compendium that's been marked as Exhibit R. I just provided a copy to the witness. And so the letter that I wanted to discuss is contained at tab 3 of the compendium. And this is a letter from George Ironside to George Vardon on September 29th, 1846. And it was stage 1, Exhibit 1-0465.
And who is it to, please?
George Vardon, Vardon.
Thank you.
And Dr. Von Gernert, are you able to help us out? Who was George Ironside at this time? Do you remember?
George Ironside, as I recall, was the local, at that time, the local representative for Indian Affairs at Manitowoc on Manitoulin Island.
Okay, and who was George Vardon, the recipient of the letter?
He was the Deputy Superintendent General of Indian Affairs.
Okay. And you discussed this letter in the second report that you prepared for stage 1. And because I find the original quite difficult to read, perhaps it might be easier to rely on your description of it in your report for stage 1, which I've included at tab 5 of the compendium. Or page, if we go to page 54 of the compendium, which is contained at tab 5. And you
Yours
note,
is in the red font.
yes, the number in the red font, 54, which is, it's page 91 of the report. So it's page 54 of the compendium.
Thank you.
And you note that, however, even a share of this resource would be difficult to recoup, as it was or would be in the hands of private mining companies. This problem was well understood by certain Lake Huron-Anishinaabe, who requested that George Ironside, and here you quote from the letter, beg of His Excellency that any mines which may be discovered shall not be subject to the enterprise of private individuals, but that the matter be taken into the hands of the government, and that they, the Indians, may receive whatever portion His Excellency may be pleased to award them. Do you see that?
Yes,
And I take it that was your transcription directly from the letter and the quote that you provide?
yes,
And so Mr. Ironside is passing on a complaint from the Lake Huron-Anishinaabe, correct?
he's passing on the Anishinaabe views, yes.
Okay. And specifically, the Anishinaabe are concerned about the difficulty of capturing a share of the value of the mining resources that are being taken out of their territory, because it's private companies that are doing the work and that are getting the profits. Is that a fair summary?
Yes,
And so they make this request for Mr. Ironside to pass on to His Excellency, right?
yes, this was 4 years before the Robinson Huron Treaty was signed. So it's in the very early stages of this whole. It's in the lead up to the treaty.
Right.
It's at a time, it's at the very time that licenses are beginning to be issued to mining companies, and the RHT Anishinaabe are concerned that they're not getting a share of this.
Okay, and I actually want to take you to what you said about this letter in your testimony in stage 1. And so I've included an excerpt from the transcript of your examination in chief from stage 1. It's included at tab 6 of the compendium, which starts at page 55 of the compendium. And what this is pages 8744 and 8745 of Stage 1 transcripts, volume 60.
Yes,
And so I want to read a portion to you. I'm actually going to start just a bit above with the paragraph just above the highlighted passage there. And you said, and what is interesting about this particular episode, which occurred at some point in September of 1846, is that they are very much concerned about that these resources would fall into private hands because they see these guys with hammers coming in and they are private individuals. They may be sanctioned by government license, but they are private individuals. And I'll just pause there for a second. The first theys that are mentioned at the start, that's the Anishinaabe that you're referring to, the Lake Huron Anishinaabe.
well, yeah, it's a certain number of Anishinaabe who've approached Ironside. I wouldn't generalize that it was all Anishinaabe. These were the individuals that approached Ironside at that time.
Okay. And at least this is their request too.
Yes,
To Ironside. And then you go on. And so these Anishinaabe are wise enough to recognize that it would be far better if the government had control over the resource rather than the private interests, because there is no way that the Anishinaabe are going to be able to approach the private interests and get whatever share they want of the mineral wealth. They would rather have it in government control so that they can then appeal to His Excellency to get a share.
yes,
See that?
yes.
And you stand by that testimony from stage 1?
Yes, that's the only conclusion I can reach based on that particular incident that George Ironside communicated.
And so these Lake Huron Anishinaabe who are making this request of Mr. Ironside, they don't want the value of the minerals to go entirely to private companies. Is that fair?
Yes,
Because if all of the profit goes to private companies, they'll never be able to get any share of the value.
yes,
And so instead, they want the government to have control over the resource.
yes,
Because that way the government can collect the value, and then rather than letting it go to the private companies, they can then distribute a share to the Anishinaabe.
yes,
And that's their preference for how they want this arrangement.
yes.
And perhaps now's a convenient time to take the afternoon break.
All right, let's take a break. Yeah, 15.
Recess for 15 minutes.
All right.
Just what we have. So you need to be seated.
Council, I know how hot it is and stuff. Trying to communicate.
Good afternoon, Dr. Von Gernert.
Good afternoon, Mr. Bass.
And so I now want to discuss treaty number 3 for a bit. And in your direct examination, you spoke about various similarities between the treaty number 3 Anishinaabe and the Robinson Superior Anishinaabe. And the point that you made, though, was that the compensation was different in treaty number 3 than it was in the Robinson Superior Treaty. Is that accurate?
Yes,
And just to situate us a little bit, the lands covered by treaty number 3 are just west of the Robinson Superior Treaty territory.
yes, the share boundary at the height of land.
And then the treaty 3 territory extends through northwestern Ontario and covers portions of eastern Manitoba as well. Is that right?
Yes,
Kind of just east of Winnipeg?
yes,
And so I now want to discuss some of the different circumstances surrounding the signing of treaty number 3. And so you'd agree that treaty number 3 was finally concluded in 1873.
yes,
And that was, we can all do the math, 23 years after the Robinson Superior Treaty was signed.
yes,
And you'd agree with me that in the treaty number 3 negotiations, there were different leadership involved on both sides of the negotiations?
Yes,
and different to the leadership that was involved in the Robinson Superior Treaty negotiations is what I'm referring to.
yes,
So, for example, obviously Chief Shinwakons and Chief Podesha are not negotiating on behalf of the Treaty 3 Anishinaabe.
yes,
And the Treaty 3 Anishinaabe, they have their own chiefs representing their various bands.
yes,
And then similarly on the Crown side, the treaty commissioners are different.
yes,
And in fact, if I'm right, Robinson had actually passed away by the time Treaty number 3 is concluded.
that's correct.
I believe he died in July 1873.
I don't recall it being that early. But it was in the 1850s.
Yeah, I actually thought it was in the 1870s, but perhaps I'm wrong.
It's, I didn't think it was that early.
Okay.
You said 1853?
I said 1873.
Oh, I'm sorry, I heard 1853. Yeah, no, definitely by the 1870s.
Definitely by the 1870s.
Yes,
Okay, I think we can leave it at that. And so the original Crown commissioners were Mr. Dawson, Mr. Simpson, and Mr. Pither. Pither?
Thank you.
yes,
And for
What
Pith,
do you mean by original?
so I'll get to that for the original negotiations up until, for the early years up until the year 1873, when Alexander Morris comes in and takes over as lead commissioner.
that's correct.
And so would you agree that from the Crown perspective, the Crown had a very strong incentive to conclude Treaty number 3?
Yes,
And so some of the reasons for that is that the Dawson route, I believe you mentioned the Dawson route briefly, this transportation route had already started to be constructed through the territory of what would become Treaty number 3 territory.
yes, the idea was to link Lake Superior with the settlements along the Red River. And the early phase of that was the Dawson route from what is now Thunder Bay to the Lake of the Woods.
And in fact, Mr. Morris was concerned that if the treaty wasn't concluded, the government would actually need to place troops along the route in order to secure safe passage.
Yes, that was, there was a fear that this passage would not be secured. And there was also, of course, the need to have troops move from Upper Canada or from what by the in the late 1860s. The need potentially to move troops to the Red River settlements because of disturbances happening in the Red River country.
Right. I'll actually get to that in a second. But another thing that was on the government's mind, I guess you could say, in the early 1870s is that they needed to build the Canadian Pacific Railway through the territory that would become Treaty number 3 territory, right?
Yes,
And of course,
Needed or wanted, it's always a-
well, and that leads me to my next question, which of course the railway was a condition of British Columbia's entrance into Confederation in the early 1870s.
that's correct.
So I guess whether you consider it a need or a strong want, there was this incentive on the government's perspective, government's mind, let's call it that.
Yes,
And so it was very important for them to secure this treaty in this portion of northwestern Ontario.
correct.
And in fact, I believe you mentioned last week that actually Treaty number 3 was supposed to be the very first post-Confederation treaty. It was supposed to be Treaty number 1.
Yes,
And comparing the Treaty number 3 negotiations and the Robinson Treaty negotiations, would you agree that there were much greater internal divisions amongst the Anishinaabe at the Treaty 3 negotiations?
I would say there were divisions in both treaties, but they were far more pronounced in the Treaty 3 territory.
And to kind of dig into that a little bit more, and in your slides, I believe it was the perspective slide deck, slide number 10. I don't know that we necessarily need to go there, but if you want to take a look, that's fine. But you give the example of the Treaty 3 negotiations nearly collapsing into a brawl in 1872.
Yes,
And the Rainy Lake spokesman reaches for his knife,
yes,
and Crown officials run to get their guns.
yes,
And in his report as well, Mr. Morris gives an example from the 1873 negotiations where the chief of Lac Seul breaks from the rest of the chiefs in a dramatic moment.
that's right.
The others try to prevent this chief from speaking, but he's able to come out and say that he actually wants the treaty.
Yes,
And Morris discusses in his reporting how he was able to take advantage of these divisions amongst the Anishinaabe in order to secure the treaty. Do you need me to repeat the question?
no, I heard the court reporter interject. I was just wondering.
Oh, she was just asking for a statement.
I'm sorry, could you repeat your question?
Yeah, so Mr. Morris, in his reporting on the conclusion of Treaty Number 3, he discusses how he was able to, when we say use these divisions amongst the Anishinaabe in order to secure the treaty.
Yes,
And so by contrast now to the negotiations in 1850 for the Robinson treaties, there's no discussion of those treaty councils nearly breaking out into a brawl.
that's correct.
No record of the negotiators running to grab their knives or their pistols.
No,
And to be fair, there on the in the Robinson negotiations, there were two holdout chiefs, Chief Shinglekons and Chief Nebinegochin.
yes,
But the rest of the chiefs were very much aligned, other than these two holdouts.
yes. The whole reason we have two treaties as opposed to one treaty was because there was a difference of opinion within the Anishinaabe ranks.
And so these two holdout chiefs that we discussed, they were both Robinson Huron chiefs, or chiefs of the area that would become the Robinson Huron Treaty.
That's correct.
But on the Robinson Superior side, the chiefs were very much aligned.
It appears so.
And so returning to Treaty Number 3, you discussed this in your testimony. The Crown had been trying to secure this treaty for years before it was finally signed.
Yes,
And you mentioned that the first attempt was all the way back in 1869.
it goes back to 1869, but the first formal councils, I think, took place in 1871 and 72.
So to break that down a little bit, so there's no treaty is concluded in 1869, obviously.
Right,
They have these treaty councils in 1871, but they're unsuccessful.
yes,
They have treaty councils again in 1872, again unsuccessful.
yes,
And then Alexander Morris comes into the picture. They're finally able to secure the treaty in 1873.
1873, yes.
And so you actually mentioned this briefly and when I was asking you some questions before, but by 1873, when Treaty 3 is finally concluded, we're now just a few years after the government ended what some know as the Red River Rebellion,
Yes,
which took place actually very close by in Manitoba.
yes,
And in fact, I think you mentioned this as well, troops had to travel through what would become Treaty 3 territory in order to get to the locations of the Red River Rebellion.
That's right. They did under Captain Wolseley, I think.
And so when Mr. Morris is finally able to conclude the treaty in 1873, after these years of failures, he's accompanied by a troop of soldiers for the Treaty Council, correct?
Yes,
And he expressly thanks these soldiers in his report. Do you recall that?
I vaguely recall that, yes.
Perhaps this is not meant to be a memory test. So I've at tab 2 of my compendium, I've actually included chapter 5 of Morris's The Treaties of Canada with the Indians of Manitoba and the Northwest Territories. And chapter 5 is his chapter on treaty number 3, or the Northwest Angle Treaty.
Yes,
And so what I'm referring to is that if you go to page 17 of the compendium, so that's 17 in the red number up top. And so if we go all the way down to the bottom,
yes,
Morris writes, I must also express my obligations to the detachment of troops under the command of Captain McDonald, assigned me as an escort, for their soldierly bearing and excellent conduct while at the Angle. I'll pause there. The Angle, he's referring to the Northwest Angle. That's where the treaty negotiations were taking place.
yes,
And he goes on, their presence was of great value and had the effect of deterring traders from bringing articles of illicit trade for sale to the Indians, and moreover exercised a moral influence which contributed most materially to the success of the negotiations.
yes,
So Mr. Morris is thanking these troops for their moral influence, which contributed most materially to the success of the negotiations, right?
yes. And to be clear, these are not, this is not the same set of troops that went to Red River because of the Troubles. This is later.
Right. We're now just 3 years later in 1873.
Yes, correct.
But Mr. Morris has an escort of troops with him at the Angle to
Yes.
negotiate this.
Right, he is the lieutenant governor, and he was often accompanied by escorts.
Including at the treaty negotiations.
Yes.
Okay. And so you also discussed this briefly with Mr. Schachter not too long ago as well, but prior to concluding treaty number 3, the treaty number 3 Anishinaabe, were aware of what was going on under the Robinson Superior Treaty. Would you agree?
Yes, they were.
Okay, and so I want to situate this in time. We're talking about, let's talk about the period 1871 to 1873 when we discussed the treaty councils were going on. So at this point, the annuities under the Robinson Superior Treaty had never been augmented,
Yes,
not even up to $4 per person.
that's correct.
And so that means the Robinson Superior Anishinaabe were still only receiving the pre-augmented annuity of $2,000.
That's correct.
Which on a per capita basis by that point, it had dropped to less than the original $1.60 per person.
By 1873?
Yeah.
Yes,
And so the Treaty 3 Anishinaabe likely knew this chain of events.
I assume so, yes.
And actually, you discussed it briefly with Mr. Schachter not that long ago. But according to Mr. Dawson, who of course was one of the commissioners concluding treaty number 3, the treaty number 3 Anishinaabe actually expressed that the quote, white man had not kept faith with their kindred at the Great Lakes. Do you recall that?
Yes,
And that was at that letter from Dawson is included at what was Exhibit Q, then became Exhibit 54, tab 27, page 147. correct?
Uh,
Good.
I don't know the page numbers, but
But you recall looking at that with Mr. Schachter.
I do.
And so this reference of the white men having not kept faith with their kindred at the Great Lakes, this was a reference to the Robinson Superior and or Robinson Huron Anishinaabe, right?
Yes.
And so would you also agree that in 1873, at least from the perspective of the Treaty 3 Anishinaabe, it was reasonable for them to conclude that the Robinson Superior annuity might never be augmented?
I don't know if I would go that far, but clearly they understood that up until that point, it had not been augmented. And it's now 1873, so it's a considerable period of time. I mean, that period of time may have led to a conclusion that it might never be augmented, but I can't be certain that that's what they thought.
Right. Certainly, they'd have no reason to know that an augmentation would come in 1875.
Correct.
And so we've discussed a number of factors, a number of circumstances of the differences in the circumstances between the Robinson Treaty negotiations in 1850 and the Treaty 3 negotiations in 1873. Would you agree that some or all of these factors may have contributed to why the compensation under the two treaties were different?
I think the Anishinaabe in the Treaty Number 3 area were intent on having a better deal. And as I said, right some time ago, perhaps last week even, they themselves had for many years requested $10. And the parties, or I should say the Crown, had always offered $3. That during the 1871, 1872 negotiations, it was $3. And Morris eventually settled for $5. And that was understood, obviously, by the Treaty 3 Anishinaabe to be a better deal than the Robinson treaties, which had not even produced the $4 promised.
So I want to zero in on one of those potential explanations and in your discussion about how the Treaty 3 Anishinaabe were intent on having a better deal. And so we just discussed that the Treaty 3 Anishinaabe expressed their awareness, if you will, to Dawson, that the white man had not kept faith with their kindred at the Great Lakes, had not kept faith with the Robinson Superior Anishinaabe. We talked about how they would have been aware up to that point that the augmentation clause under the Robinson Superior Treaty had never been augmented and still remained at that point less than $1.60 per person on a per capita basis. And so knowing all of that, you'd agree with me that those factors may well have discouraged the Treaty 3 Anishinaabe from a wait and see approach to compensation, or an approach that would have required the Crown to augment their annuity in the future.
Well, that's very speculative. The fact of the matter is that the Crown never offered that as an option. The Crown offered a fixed annuity of $3. They wanted a fixed annuity of $10. and the parties settled on $5.
So you wouldn't agree that it would be reasonable for the Treaty 3 Anishinaabe not to demand a wait and see approach to compensation, seeing that this wait and see approach to compensation with an augmentation clause in the Robinson Superior Treaty had not been fulfilled and the white man had not kept faith with their kindred?
Yes, I think that the Treaty 3 Anishinaabe would have preferred to have a guarantee of $5 instead of an augmentation clause that only gave them $5 at some point in the future.
Right, it might be reasonable for them to want a very specific list of items that could be written directly and specifically into the treaty and would be due immediately, so they wouldn't have to run the risk of the white man not keeping faith with them.
Yes,
And that's why they might want annuities and goods in amounts that would be identified in the treaty with remarkable specificity down to the number of bushels of peas a chief receives every 8 years.
well, the reason for that model is not so much a reaction to the Robinson augmentation clause and the failure for it to have been realized by the 1870s. The reason for the original list is simply because that's how the numbered treaties, because there were 2 of them by that time, had already established a pattern. That is, you receive, in addition to your $5 or $3 or whatever fixed annuity, a number of goods and other promises. And so they were basically patterning, they were creating a list based on an expectation that the Crown would provide them that kind of model for the treaty. I mean,
Well, and it would have been reasonable for the Treaty 3 Anishinaabe to accept such an arrangement because it leaves no margin for interpretation and it doesn't depend on the Crown agreeing when an increase was due in the future.
yes, it certainly would have been more attractive than the Robinson model, which whereby your promised annuity doesn't materialize until some economic condition had been met.
And because the white man might not keep faith with that promise.
That may have also been a consideration on their part, yes.
So in your testimony last week, you pointed to the list of demands of the Treaty 3 Anishinaabe as something that you claim undermined Dr. Dribbin's testimony that the Robinson Superior Anishinaabe would have wanted an augmentation clause that was generous but would not overwhelm the Crown. Do you remember that?
Yes,
And that's because you say that the initial list of demands from the Treaty 3 Anishinaabe did overwhelm the Crown.
yes.
And that's your opinion.
It's my opinion based on Morris's reaction.
Okay, well, let's talk about Morris's reaction. Morris doesn't say that the demand would overwhelm the Crown. He doesn't use that language.
No, he doesn't use that language. That's Dr. Dribbin's language.
Okay. Well, and so if we go to tab 2 of the compendium, page 14, or yes, the red number 14. And I'm going all the way, let's 3/4 of the way down the page. The line on the side starts adjourned until the next day. Do you see that? And then the sentence after begins on the 3rd October.
Yes,
What tab?
Tab 2, it's red page 14. in the compendium. We're still in Morris's Treaties of Canada. It should be tab number 2.
Sorry, I was in
That's all right.
17.
14. And so Morris writes, on the 3rd October, the chiefs again assembled and made a counter proposal, of which I enclose a copy, being the demand they have urged since 1869. I also enclose an estimate I had made of the money value of the demand, amounting to 125,000 per annum. On behalf of the commissioners, I at once peremptorily refused the demand. That's what
Yes.
Morris says, right?
yes.
He doesn't say that this demand would overwhelm the Crown.
Well, it's quite obvious that the amount of 125,000 per annum was way above anything that he had a mandate to agree to. Morris's mandate was very clear. He could not offer anywhere near that amount. So in that sense, of course, it overwhelmed the Crown.
So you interpret the phrase overwhelm the Crown as being beyond the mandate of the commissioner.
The amount is what overwhelmed the Crown, because it was so far exceeding what the government was prepared to offer.
But all Morris says is that he peremptorily refused it.
Yes, Morris does not use Dr. Dribbin's words.
Okay. And you didn't double check Morris's calculations to confirm that his estimate of costs was accurate?
I went through, I remember seeing the document in which he makes these calculations. I can't say one way or the other whether they were accurate. He was better positioned to know what things are worth in 1875 than I am.
Okay. And obviously at the time, even Morris couldn't know the precise amount of net proceeds that the Crown would obtain from the Treaty 3 territory in the future.
This was not in the contemplation of Morris at the time of treaty.
Right. He didn't even consider what the net proceeds from the territory would be to the government over the years into the future.
That's correct.
And shifting from Morris's perspective to the Treaty 3 Anishinabe's perspective, they believe their lands to be very rich, didn't they?
They did.
And in fact, at the Treaty Council, one of the chiefs speaks about the sound of the rustling of the gold under his feet.
Yes, a famous passage, which I repeat in my report.
Right. And actually, so I'd like to go to your report, into the perspectives report at page 40, where you discuss this. And I'm going down towards the bottom of the first large paragraph on the page, a couple sentences from the end that starts with "to be sure."
Yes,
You see that? I see that Miss Lewis has brought it up on the screen as well.
The number on the perspective. 50.
Exhibit 50. Thank you.
Got it.
And we're at page 40.
Thank you.
And you write, "To be sure, the original Anishinaabe list And by the original Anishinaabe list, you're talking about the list of demands that we've been discussing.
Yes,
You're right. The original Anishinaabe list had expensive demands because the lands were rumored to be rich, and it was thought the government should be able to afford the expense.
yes,
And by it was thought the government should be able to afford the expense, do you include the Anishinaabe in that phrase?
it's only the Anishinaabe,
The Anishinaabe thought the government could afford the expense.
yes,
So they believed that their demands, though they were high, could be afforded by the government because of the wealth of the territory.
yes,
And then, of course, we know at the end of the day, the treaty number 3 Anishinaabe end up settling for an amount less than the original list of demands, right?
yes.
So I want to move on, Dr. Von Gernot, to discuss broad human universals. And you criticized Dr. Driven's report for his alleged reliance on what you term broad human universals.
I don't so much criticize him for reliance on it, rather I make the point that it doesn't seem to me that they are helpful for the specific task at hand.
Okay, fair enough. Thank you for that clarification. And the examples that you provide are Dr. Driven's reliance on concepts like reciprocity or happiness or the good life.
Yes,
So let's start with the concept of reciprocity. In your work, you didn't specifically consider how the concept of reciprocity may have been conceptualized or expressed or understood by the Anishinaabe people in 1850.
the concept of reciprocity is a universal. And so I was of the view, and still am, that they had a concept of reciprocity.
And so because it's a universal in your view, you found it unnecessary to consider how the Anishinaabe people in 1850 may have specifically understood or conceptualized that concept.
That's correct.
And so you didn't consider any scholarly work or secondary sources that have been written on the topic?
Specifically on Anishinaabe notions of reciprocity?
Yep.
No.
And you didn't consider the relative importance of something like reciprocity in Anishinaabe culture. And by relative importance, I mean, you know, the relative importance to the Anishinaabe people of this concept as compared to other concepts or other ideals.
Well, I didn't see that in Dr. Driven's report. So as a consequence, I found no need to respond.
And another human universal that you discuss in your response to Dr. Driven is his use of happiness, correct?
Yes.
And I think in your report and possibly in your testimony as well, you asked the rhetorical question, what members of the human species do not want happiness?
Yes.
And I'd be correct to say that your report doesn't examine the term Minobemadzewin?
Well, I'm familiar with it, but if it's expressed, if it's simply the expression of happiness and leading the good life, then again, I don't see how such a general notion can assist in a specific task. I don't disagree that they have this notion. I mean, it is reflected in the literature that Dr. Driven produces.
Okay, and to follow up on that, you said in your answer, if it's simply happiness or living the good life, I take it you're not a speaker of Anishinaabe-Moan?
That's correct.
And in your report, you don't discuss what other elements the concept of Minobemaatsuen might entail.
No, I was just responding to Dr. Driven.
And so your response and your response to Dr. Driven and his reliance on the concept of Minobemaatsuen is really based on the translation of the term as either happiness or the good life. Would you agree with that?
Yes, it's based on how he uses it in his report and conclusions numbers 1 through 4.
But as you said, you didn't engage in an independent analysis of the contours of what this term might mean in Anishinaabe philosophy or Anishinaabe theology.
No, not beyond making the point that there is no such thing as a single Anishinaabe theology or understanding.
I note the time, Your Honor. I would estimate I probably have about half an hour left to do. I don't know if the court is willing or able to sit later this evening to try and finish up with this witness, or I could perhaps finish one more area.
I'm willing and able, but I'm not. It's hot. And I don't want to push people past it. It's just that I saw your face, I saw your face as we started to.
All right, well, I think we're here. We either inconvenience ourselves a little bit to spring Dr. Von Gernert today, so he's never know how to. I favor the former. Have a short redirect, very short redirect.
So that's past 5. I say we have more days this week, folks. And I am very sorry, sir, if it needs another.
I wonder if he's deserve accommodation. I mean, that's.
What are you saying? Is your preference to go on?
I would prefer to go on and finish the cross-examination, finish the redirect or anything arising from the redirect. That's my preference. I think it's awful to Dr. McCarran, who's been here for a long time. And probably wants to get on his way. I don't know that for a fact. I don't know if he has accommodation tonight, but that's what I'm suggesting. Just plow through. We may find ourselves in the morning starts. It's almost here so long too. So that's where we are, but I'm in everybody else's hands, especially yours.
We're also like for 10, so you can sit late.
We're happy. Yeah.
Okay. Whatever.
I'll have Ms. Lewis already departed.
Okay. And thank you, Dr. Von Gernert. I will try not to be too much longer with you.
But I do want you to do what you plan to do.
So the next area I wanted to discuss with you is the issue of the Robinson Huron Treaty boundaries. And on Monday, you were being questioned by Counsel for Canada, and you were asked questions about the efforts to determine the Robinson Huron Treaty boundary. Do you recall that
Yes.
exchange? And you were asked why Ontario didn't ask the Anishinaabe in Ontario about the boundary, and your response was, quote, because the Anishinaabe didn't know the boundaries either, nobody knew the boundary. Do you recall that?
Yes,
And I correct me if I'm wrong, but I think inherent in your answer is that Ontario did not in fact ask the Robinson Huron Anishinaabe themselves about the boundary. Is that accurate?
no, Ontario had received information from their Indian agents on the ground. I'm sorry, Ontario received their information on the boundary from Canada, and Canada had received its information from their Indian agents on the ground, who informed that the RST Anishinaabe and their neighbors to the south, to the immediate south of them, had agreed that the boundary between them would be at Moose Deer Point. And that's how that line for the southern portion of the boundary was established by Canada, which then in turn provided that information to Ontario. As for the eastern portion, which Canada thought started at the eastern end of Lake Nipissing and went south to meet that southern boundary that had a latitude of Moose Deer Point, that boundary was more arbitrary, and it was simply established because it was in the closest line, which was the Bobcaygeon line, was understood to be more or less where the height of land was between the Georgian Bay watershed and the Ottawa Valley watershed. So Canada assumed that that would be the boundary, and that's actually corroborated by Vidal and Anderson in 1849 when he asked the Anishinaabe, you know, how far back does your claim go? And they said, well, it's up to the height of land.
I
So
wouldn't mind, we might get to your full explanation, but I thought the question was, are you implying that Ontario didn't ask?
yes, Ontario did not ask. Ontario relied on Canada for the boundary.
Okay. And so I think kind of inherent in that long answer that you just gave, but I want to break it down a little bit because you discussed some of this in your questions from Ms. Evans as well. And when she asked you what information did the Dominion have that allowed Meredith to make his approximations that Ontario didn't have, and you discussed Moose Deer Point, and you stated in your evidence on Monday, this was where the Anishinaabe who were to the south of Moose Deer Point had stated that their boundary with the RHT Anishinaabe was at Moose Deer Point. And so I take it from that the Anishinaabe who lived south of the Robinson Huron Treaty area, they knew, or let's be fair, they at very least had a position on where the boundary was.
They had a position on where the boundary was, yes.
Okay, and that's because they knew where their traditional territories and their traditional hunting grounds were.
At that time, they understood that their traditional territories did not go north of Moose Deer Point, the Moose Deer Point line.
And so probably reasonable to assume that the RHT Anishinaabe just north of there similarly had, let's say at the very least, a position on where the boundary was and where their traditional territories or their traditional hunting grounds lay, or to put it another way, where their just claims lay.
Yes, it's unclear how the Anishinaabe south of that boundary had, how or when they had come to that agreement with their northern neighbors. But they claimed that they had agreed.
And so I'm just trying to understand and maybe clarify the statement that you had made on Monday, that the Anishinaabe didn't know the boundaries either. Nobody knew the boundaries. So at least the Anishinaabe living south of Moose Deer Point, and potentially now the Anishinaabe in the Robinson Huron Treaty territory, they at the very least would have had a position on where the boundary was.
They had a position at the time. Of course, that position changed over time, which is why, you know, the Williams treaties has overlap between the two. They're not mutually exclusive. The Anishinaabe south of Moose Deer Point ended up claiming lands in the RHT territory, and hence their inclusion in the Williams Treaty. So it was not a traditional territory that was set in stone.
And let's just talk at least prior to when Mr. Meredith makes his approximation in the late 1870s. Up to that point, the Crown, whether it's the United Province of Canada, Ontario, or the Dominion, they never gathered the Anishinaabe together, said, let's sit down and let's discuss where the boundaries are.
I have no knowledge of such a discussion.
Okay. You testified throughout your evidence that over the years, various Crown officials raised the suggestion of developing a capital fund that would be used to fund the augmentation, right?
Yes,
And you mentioned this specifically when discussing various options to determine when the augmentation clause was triggered, right?
yes,
And you point out some officials who had this view, like Russell in 1857
yes,
and Sprague in 1873.
yes,
And so just so that I am sure that I'm clear on this arrangement, what would happen is that the proceeds from the territory would go into a capital account, and then the interest from that capital sum would be used to fund the augmented annuities.
yes,
That's what they had in mind.
yes.
And of all the Crown officials that suggested or raised this option over the years, none of them argued that the amount that should go into the capital fund to produce the interest should be some risk-adjusted portion of the proceeds. And by that, I mean some portion of the proceeds that is adjusted down based on the risks that the Anishinaabe would have considered back in 1850.
I honestly don't know what you're talking about.
Let me,
Somehow, sir, you must have missed the first 2 weeks of economic evidence.
oh, so none of these Crown officials suggested that if we're going to build this capital sum, the amount that goes into the capital sum is not the proceeds of the land, but some lesser portion of the proceeds that we need to adjust downwards based on the risks that we believe the Anishinaabe would have viewed in 1850 of the returns from the land.
I have found no evidence whatsoever in the voluminous documentation that I examined that anyone was talking like that.
Okay, fair enough. Only a bit more to get through, Dr. Von Gernot. And I think it'd be fair to say that in creating your just demands report, you reviewed a voluminous record of original documents.
I would say so, yes.
And yesterday, and then some this morning as well, Mr. Schachter went through many of those documents with you.
Yes,
Most were included in your report. I believe there were a few that weren't.
yes,
And so when you went through this voluminous record of documents, you need to select which ones to emphasize or focus on in your report.
Well, every historical writing is a process of selection. Not because you're producing a document that is to advance your confirmation biases or to promote some kind of a priori opinion, but rather because when you're writing the story of what happened in the past, you necessarily have to select things from the record for emphasis and either ignore or not consider other documents, because there's a great deal of material in this record which has only tangential or any kind of relevance to the story.
Okay. And one of the documents that you discussed with Mr. Schachter, it was the 1864 speech from the council at Garden River by Pequichinini, and that was included in Exhibit 54 at tab 14. Do you recall that? Or do you want to go back to the document?
If you could,
Sure. Do you still have a copy of Mr. Schachter's cross-examination compendium? It's quite a bit larger than mine.
yes, I do.
Okay. And I'm referring to the document at tab 14,
Yes,
which was the reports of the inspectors of the free ports of Gaspé and Sault Ste. Marie.
yes,
You recall that document?
I do.
And in fairness to you, you noted that you weren't aware of this document when you first wrote your report.
Yes,
And so for that reason, it obviously couldn't be included in your first 450-page report.
correct.
And you noted that you only became aware of it from reading Dr. Boeker's reply report.
It's the first time that I heard reference to it. And I went through the whole record of what the parties had assembled prior. And I do not recall seeing it there. So this was literally the first time I seen it.
Okay. But you had seen it before Mr. Schachter asked you questions about it yesterday, I believe. May have been on Monday.
I had seen it in his compendium and I recognized that it was the one that Dr. Bohacker was referring to in her report.
Right. Okay. And yesterday, when discussing this document, you told the court that it caused you to, quote, think how much reliance I should place on the Carney evidence. Do you recall saying that?
Yes,
And you were referring to Carney's 1858 letter to Pennyfather?
yes,
And that's the letter that you dedicate a whole subsection of your report to under the heading Carney's views in 1858. And if I believe that's at page 150 of your just demands report.
I'm sorry, which,
The just demands report, page 150. You have a subsection entitled Carney's views in 1858,
yes,
and that's where you discuss this letter.
correct.
And so this is the letter that when you became aware of the 1864 speech, it made you rethink your reliance on this Carney letter. That's what you told Mr. Schachter.
Yes, what I was talking about here is that here there is a Carney was given an impression that the Anishinaabe were to receive 600 pounds per annum for 4 years, and after that, $4 per head. Whereas in the inspectors of the free ports of Gaspé and Sault Ste. Marie report, there is a recollection that Mr. Robinson promised us that the land should be surveyed and sold, and at the end of 1 year, we and each member of our people should receive $4 in cash, and that the rest of the money would be invested at interest for our benefit. So that's quite a different recollection from the one in Carney. And so my initial response to that, as I articulated in my response to Dr. Bohacker, was that what does this tell us about the recollections, oral histories, or understandings of the Anishinaabe over time, when you can have such differences? And that led me to the comment that when you have that much of a discrepancy, how much we should really rely on any of these.
Either the Carney 1858 letter or the
Yes.
Okay. Though in your examination in chief in this court, you continue to rely on the 1858 Carney letter, and you discuss it at slides 42 to 44. Those are your just demand slides. And again, this was under the heading Carney's views in 1858.
Yes.
And on slide 42, you specifically mention that Carney reported that the Anishinaabe, quote, believed that they were to receive 600 pounds per annum for 4 years, and after that, $4 per head.
Yeah, so, I mean, this is a very unusual circumstance because the slides are supposed to reflect what was in my report. And my report is not the only report I wrote. I wrote a response to Dr. Bohacker's report, which is not in evidence. And so it
And you
can't
knew
go into
prior,
the slide.
and you knew prior to testifying that your reply report to Dr. Bohacker was not in evidence.
Well, I assumed so, yes.
And I think you got ahead of me a little bit, but you'd confirm any reference to the 1864 speech from the reports of the free inspectors of Gaspé and Sault Ste. Marie, the one that you said made you rethink your reliance on the Carney letter. It doesn't appear anywhere in your slide.
That's correct.
And you didn't mention it at all during your examination in chief.
That's correct.
Thank you.
And when you discuss the 1858 Carney letter at slides 42 to 44 of your slide deck, or in your oral testimony when you were describing it, you didn't mention that you had reconsidered the weight that you gave it in your original report on the basis of this conflicting recounting of a speech by a member of the same community, the Garden River community, who was actually present at the Treaty Council in 1850. You didn't mention that when you discussed this in your slides or your oral testimony.
That's correct.
And so again, this was a choice that you made regarding which aspects of the historical record to rely on and focus on in your testimony.
Yeah, I think that's a fair point. My slide deck was supposed to follow my report. My report is what's given in evidence. When Mr. Schachter raised this document, I was happy to give the same evidence I gave in my reply to Dr. Bohocker's report, that offered an opportunity to do so. Beyond that, there's nothing more I can add.
But you'd agree with me? I mean, you mentioned your report was your evidence, but your testimony in this court is also your evidence, correct?
Yes.
And you're not suggesting that you were precluded or prohibited from mentioning the 1864 speech in your slide deck for any reason, simply because it wasn't in your original report?
No, I'm not suggesting that I was precluded, but my understanding is that I cannot provide evidence outside the four corners of the report that I produced and was in evidence.
Even though you
So-
had come to reconsider the weight that you were placing on one of the documents that you refer to specifically in your report and in your slide deck.
As I said, this would not be an issue at all because my opinions about this are on record in my response to Dr. Bohacker. It would not be an issue at all were it not for the unusual circumstance that my opinion was essentially deleted as a consequence of a decision by the RHT plaintiffs to pull out.
Which you mentioned you knew prior to taking the stand.
Yes.
Let's move on. Do you recall that you provided expert opinion evidence to the federal court in the Daniels case?
Yes.
And I've included a excerpt from that case at tab 10 of my compendium. And for the record, that's Daniels in Canada, Indian Affairs and Northern Development, 2013 FC 6. And would you agree with me, Dr. Von Gernert, that in that case,
I'm
Justice,
sorry.
Oh.
What,
Pardon. Tab 10 of the compendium
yes.
is an excerpt from the Daniels decision. Didn't mean to mention. But you'd agree with me that Justice Phelan, in that opinion, he was critical of your evidence?
Yes, as I indicated at the very beginning during my qualifications, some courts accept my evidence and laud my objectivity and the detail with which I produce my reports, and others think that I didn't do a good job, and that's fine. I don't have any problem with that.
Well, I want to focus for a minute specifically on what Justice Phelan said about your evidence in that case. And so on the next page, page 66 of the compendium, that's red page 66, there's an excerpt of paragraph 181 of the Daniels decision of the federal court. And Justice Phelan wrote, "Unfortunately, Von Gernert exhibited a shallow understanding of many of the documents he relied upon, or was unexplainably selective in his use of evidence. Thus, his evidence stood in sharp contrast to many of the other witnesses on both sides in terms of knowledge, reliability, and credibility." And so that was part of Justice Phelan's criticism of your evidence in that case, correct?
It would appear that way. And I mean, there are identical paragraphs saying the exact opposite thing by other courts. So as I said, I try to provide the best possible scholarly work that I can muster. And I don't think I have no control over how my evidence is used or how it's understood. That's fine. I don't worry about things that are out of my control. I only worry about trying to do the best that my profession has given me, the skills that I've learned. I wrote a voluminous report in the Daniels case. If it was considered to be unhelpful or understood to be shallow, that's fine. That's not the experience in other courts, so
Okay.
I'm fine with that. It's not a, you know, I could only do what my profession has given me the skills to do. And whatever somebody says in some other context or other court about my work, whether good or bad, I have no control over.
Well, I'm going to suggest to you, sir, that as in your testimony in the Daniels decision, here you have been unexplainably selective in your use of evidence, as you were with your choice not to mention the 1864 speech of Chief Pequichinini in your slides or in your testimony in this court. Do you disagree?
I disagree.
I only have one more area to cover with you, Dr. Von Gernert.
Can I ask one question? So during your qualification, and I can't remember who was asking the question, but your plaintiffs, there, you went through review of and I don't remember what the question was. Possibly, you know, was your evidence always accepted or something? I don't recall what the question was, but your answer was, but in that case, they misconstrued my evidence.
Yes.
You might recall that. And I said, who is they? You said court. And I'm just wondering if that was the Daniels case.
No, that was,
I believe that was a reference to the Chilcotin.
yes.
Okay.
So, Dr. Von Gernert, you've been very patient with all of us these last 2 weeks, so I only have one more area to cover. You explained throughout your report that many Crown actors at different points in time assume that the annuities had an upper cap of $4 per person. Is that fair?
Yes.
And you outline these understandings in great detail in both your report and in your testimony before this court.
Yes.
And you had a long discussion with Mr. Schachter, I believe it was yesterday, about the nature of how Crown actors may have been wrong, whether deceitful, bad actors, willfully blind. I'm not intending to get into any of that right now, but would you at least accept that these Crown actors may have been wrong in this assumption, regardless of how they were wrong?
Yes.
And indeed, given the interpretation of the augmentation clause that was upheld by the Court of Appeal, they were mistaken.
Well, when set against the standards of a 21st century legal decision, they were mistaken.
That wasn't exactly my question. So maybe I'll rephrase it. If we accept the Court of Appeal decision, they were mistaken.
Yes.
And I believe you actually mentioned this in your testimony as well. You understand, having read the Court of Appeal decision, that the role for this court in this stage of the trial is to determine what kind of sharing the augmentation clause requires and what increase is necessary in the annuities to fulfill the treaty promise, or more particularly, to determine the form, level, and aim of the sharing that the augmentation clause requires. You understand that to be the task of this court?
Yes.
And given that task, if we accept that the Crown actors in the late 19th century were in fact mistaken in their understandings, again, regardless of how they were mistaken, that their mistaken views tell us little about the form, level, and aim of the sharing that the augmentation clause requires.
That's quite possible. But my reports were done for various purposes. The large perspectives, or I should say the large, their just demand report I'm not sure why I was asked to produce a history of government efforts to pay annuities specified in these treaties, but I can only assume that had something to do with Crown conduct. And so I'm not sure whether the tasks that you described that this court needs to decide is limited to just the confines of what you just articulated.
Well, fair enough. There may well be other tasks that this court must engage in stage 3, but for this specific task, this is one of the tasks that the court, Her Honor, is going to have to decide at this stage of the trial. And at least for that task, you'd agree that the mistaken views of Crown actors are not particularly helpful. They don't tell us particularly much about the form, level, and aim of the sharing that the augmentation clause requires.
Well, whether or not my reports are helpful, I'll leave for this court to decide.
All right. I guess I'll leave it for this court to decide as well. Thank you very much, Dr. Von Gurney. You've been very patient with all of us. It's been a long, hot day. Those are all of my questions for you.
Realize Dr. Von Gurnett probably asked you.
It's all right, Your Honor. I'd rather have it go beyond the usual time than have to stay another night in your wonderful city.
Well, it's Red Bull or coffee.
Well, they're gonna be. Hello, once again, Doctor.
Yes, it's been quite a while.
May we have exhibit 2838 from stage 3 up? I think we do.
Is that what you just handed up?
Yes,
28.
2838.
Okay.
Okay, so now this begins.
Sorry. Is it 2838 a 4-digit number or 28 and 38?
It's 1-2838.
Thank you.
So I'm told from the JVD. Now oddly, this point of clarification, and it really is a point of clarification, arises from the very last page in Exhibit 54, the Schachter Compendium. We could look at that. And Mr. Schachter put to you, it's the very last page. It's tab, I don't think the tab probably matters, 27.
But tab 175 or page 175.
Right.
Thank you.
Now, Mr. Schachter put to you the last, put to you that document, and at the very last sentence, it says, the subject of the claims of the Indians to increase.
Objection.
I'm not,
if my friend is going to be telegraphing an answer to the witness, that's not fair. If he wants to say that it's how Mr. Marcello reads the document, that's okay. And he can ask a question, but he shouldn't be leading the witness this way.
I'm reading the exact document. I'm reading the document he put to Dr. Von Gardner. I'm not reading that. We'll come to that.
You're reading.
I'm reading the exact,
175?
Yeah.
All right.
the subject of the claims of the Indians to increase of annuity at an increased rate will be brought up for early consideration. Do you see that?
Yes.
Now,
So the last line.
last line,
Thank you.
is that this is a document thing. I think there's point to
I
clarify.
just have to follow you.
So now we have lost the screen. 2838. Now, if you scroll through this, if you're able to scroll through this, keep going, take us right through to the lines that I just read, if you can. And, okay, right there. That's the key part, Your Honor, that I'm going to ask you about. Right there. As I said, you have a hard copy. Now, if we go into your report at page 270, if we can get that up.
Yes, I refer to this at footnote 563.
Right, so you
You referred to it.
To the difference between the printed versions and the original archival version.
in the first paragraph, at the end of it, you say, 2 days later, Deputy Minister of the Interior Meredith finally had some good news for Boren. And then
Sorry.
page 270 of the Crown Conduct Report. I didn't give you a hard copy of that. It's just
No,
up on
I'll
the screen.
find it.
It's just-
Such a just man.
Yes. Two days later, Deputy Minister of the Interior Meredith finally had some good news for Boren. And you see 2 paragraphs there, and then you see the 3rd paragraph that's the focus of this reexamination. It says in your report, the subject of the claims of the Indians to arrears, not to increase as in Exhibit 54, but to arrears, claims of the Indians to arrears of annuity at an increased rate will be brought up for early consideration. And I just, and you footnote to that and you identify certain things, and I would like you to clarify the role of this document for Her Honor.
Yes, so I rely as much as possible on the archival versions and not on the printed versions, no matter how convenient the latter may be. And I found that in this particular instance, the printed version substitute the word increase for arrears, which is actually the word that's evident in the original. And it also, as I said,
And
makes,
sorry, there was a document put on the screen
yes,
that you didn't identify. Are you saying that?
It's this, yeah.
That the handwritten document form that's on the screen is what is transcribed at page 175 of the compendium?
Well,
When I'm
well,
just asking, what is Dr. Bennett said in the printed version? Which of these 3 documents are you?
so the printed version, an example of the printed version is the last page of the compendium that Mr. Schachter put to me.
Okay, so that's page 175.
Yes.
Okay, thank you.
I'm sorry, do have to object. The witness has identified it as the letter, but he identifies it in his report as a draft. There's a big difference between a letter and a draft, and the court should not be that's not fair.
I have to admit. I don't really follow the question. Partly because I was trying to. Fill what the- So you said it was a question put to the witness that didn't say it was a draft.
I think his answer was, sorry, what's happening here is that there is a document I put to the witness towards the end of my cross-examination.
Well, then
I-
let's, what do you,
Let's finish with that.
At the end of my cross-examination, on 2 occasions, I asked him, is there anything more you want to tell us about Mr. Laird's memo? He said, no. My friend is doing redirect. He's directing him to a discrepancy in what he has identified as a draft of the letter I put to him. And he identified the version, the draft version, as the original letter. Right? So I think there's a difference between a draft letter and a letter that I put to him. So I don't think it's fair to the court to make it appear as though a draft letter is the letter that actually went out. That's my point.
So this document was not put to Dr. Von Gernert. I'm just saying to him, put it in perspective for us here. You're referring to a different document. If you think it's a draft document.
So I didn't have a chance to
Oh,
consider it.
okay.
And,
I'm sorry.
best properly identified? Is it properly put to a witness? Was asked the question? Is there anything else? It's redirect. You all know the confines of redirect are so narrow.
Yeah, and this is an unclear point because what's in Exhibit 54 has a different word in it than what's in Dr. Von Gernert's report. And I'm asking him, because that has now come up as a result of this document being put to him in cross-examination. I'm asking him to comment on where this other document he refers to fits. And if you're concerned about it being a draft, as opposed to like in the sense that my friend appears to think, he can address that. He calls, I mean,
Signals do that.
well, I'm sure he'll be straight up about it. I just want him to tell you what he's saying about this document in his report, because it's different than what was put to him in cross-examination.
I don't want to stop my friend from putting the document to the witness. You know, I think the court, if it helps clear anything up for the court, that's fine. But it should be done fairly for the court. That's all.
It's not been done unfairly.
Well,
The footnotes are,
You don't answer.
Yeah.
Mr. Chairman. That's not what you're saying.
right?
And you're saying just properly identified.
Yes, and
Mr. Marcelo?
So it's the letter,
I think that's correct. If it's identified differently than the letter. then you
the
should-
letter you're referring to at page 270 of your report. You consider that a draft letter, as in an unfinal letter?
The only thing that the only original that I found in the archives or in the archival record was what I footnote at footnote 565, which is the original file in the Library and Archives Canada. That's what I quoted from on page 270. Those are the 3 paragraphs. And then I noted at footnote 563 that printed versions substitute increase for arrears, although the latter is evident in Meredith's original draft and makes more sense in context. See next footnote. And then I provide the context by which the only written version that we have makes more sense than the printed versions. And I should say that the printed versions,
I'm really going to ask you to use court descriptions of these documents, because I don't know when you say written and printed.
okay,
So we've got page numbers or exhibit numbers.
all right. So on page 270
Yes.
of my expert opinion report, they're just demand.
I have all three before.
Yes, there is a quotation from Meredith to Boron, in which Meredith is advising Boron that the payments are going to be increased to $4 per head. And he adds in the last sentence, the subject of the claims of the Indians to arrears of annuity at an increased rate will be brought up for early consideration. And I footnote Edmund Meredith in the only written version of this that we have in the archives at footnote 565. And then I note that the transcript with errors are preserved in the sessional papers. And so what you have in Mr. Schachter's compendium, last page, 175, is one of these written, one of these printed versions. And I'm not sure whether it's from the sessional papers. I can only assume that that's where it's from, because it doesn't have an attribution. And you will note that there's a difference in the wording.
I'm very sorry to do this, but I just ask you, you said the quote you have on page 270, what do you call that version?
That is the original handwritten.
On
Ver-
page 270, I don't see anything handwritten.
No, well, I transcribe
It's
it.
a transcription of the original.
Yes.
handwritten. Okay.
Yes. It's my transcription of the original. And then I also note that, and of course, that is referenced at footnote 565. But the word arrears, I footnote that in printed versions, there's a substitution in which it's increase instead of arrears. And then I go on to say that indeed that makes the original arrears makes more sense in the context, which I explain at footnote 564.
I have nothing further.
Yeah, there is a matter that arises because of that, because we really do have to clear this one area up. We're going to go right back to your page 270, Dr. Von Gernet. in the middle of the page, on page 270, you have a transcription of a document,
Yes,
correct? That document was originally in handwriting, correct?
yes,
That handwritten document that you reviewed is described in footnote 563 as Meredith's original draft. What you transcribed is Meredith's original draft, correct?
yes,
And what I showed to you was a printed copy of a document which you say is transcribed with errors, but I say is part of the official correspondence in 1877 of the sessional papers.
yes. As I say at footnote 565, there's a transcript with errors preserved in the sessional papers. And as-
Well, but you're assuming it's an error because you think it makes more sense, right?
no, it's an error, both because it makes more sense in the context of Meredith's response to Boron's inquiry. And when I read the original, I see arrears as opposed to increase.
Sir, the original is a draft. It's not evidence of what went out. Do you agree?
It's the only written document we have. We do,
But we,
there is no other,
Would-
the archival record does not contain any other written version of this by Meredith. It's the only one.
what we do have from the archives is official correspondence collected in 1877 with the words I put to you. Do you agree with that? Not asking you if it's an error, but it's official correspondence compiled in 1877, correct?
It's a list, yes, in 1877, there was a compendium of all the correspondence relating to the Robinson Treaty annuity issue. And as I note throughout my report, it contains errors from time to time.
Meredith was alive in 1877.
He may have been, yes.
He was alive at the time the official correspondence was put together, and if there was confusion about what the letter actually said, that actually went out, someone could have communicated or discussed it with him.
I wouldn't go so far to think that, you know, after the fact, these people were proofreading the sessional papers. They weren't doing that. There are so many errors in these sessional papers, and which is why my practice is to go back to the original in the archives and still note the discrepancies between them.
But we don't have the original letter that was sent out. We've only got a draft.
We have what we have. And I found a discrepancy between the two, and I found reason to accept the wording of one because it,
Sir, do you mean by accepting the wording of one? Say, I chose to accept the wording of one. You
yes,
chose to accept that it went out. Is that what you're saying?
no, I accept that Meredith's intent was to use the word arrears as opposed to increase. And that, as often happened, a mistake was made in the reading of his letter when it was transcribed. And this isn't the first time this has happened. This is demonstrably true on
Okay, let's not-
many
let's not go
occasions.
off track.
Can you scroll down, Ms. Lewis? Just to some, just to stop right there. Lots of lines, lots of interlineations,
Yes,
lots of strikeouts. It's a draft.
yes,
And you choose that to take the you put more credence in a draft than you do in the official correspondence. Is that fair?
no, you don't, it's improper to characterize something as official correspondence when the intent of the sessional papers was simply to provide a record for the use of parliamentarians to assess what correspondence was going on between various government officials.
Would you agree with me, sir, that it's described in the sessional papers as official correspondence?
Well, yes, it is correspondence between officials.
No, it's. Can we go to the beginning? It's the sessional papers, it's official correspondence. That's the, I think that's the title of the document, is it not? Let's just bring up the top of, I guess it's, yeah. 2303. Let's see what it's called. Maybe I misdescribed it. I thought it was official correspondence. Maybe it's only sessional papers. Okay. That's okay. All right, so it doesn't use the word official. I stand corrected. It does use the word sessional papers and well, I guess we'll just it'll be the subject of argument, I suppose. I don't have any further regret.
Thank you very much. It's my chance to thank you for being here, for the work that you have brought to this court and contribution. And for the respect that you have shown. Thank you.
Thank you so much.
Oh, okay. How are we doing?